The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about a shareholder's right to inspect company records for Illinois LLCs and corporations. We'll talk about corporations first, and then we'll move on to LLCs. So, corporations. The Illinois Business Corporation Act provides that shareholders of a corporation are entitled to access of the following types of documents for a proper purpose: the complete books and accounting records of the company, meeting minutes of shareholders and directors, and records of the identity of the corporation shareholders. This is not an exclusive list. Illinois case law has established that if a proper purpose exists, the shareholder has a right to inspect all books and records necessary to make an intelligent and searching investigation in order to better protect his or her interests. So the term proper purpose is very important, because as long as there's a proper purpose, the shareholder can really inspect any type of record. So what does a proper purpose mean? This has been interpreted broadly by Illinois courts, and it includes any honest and good faith purpose that seeks to protect the interests of the shareholder or of the corporation. Courts have distinguished this from a fishing expedition based on mere curiosity. If a shareholder wants to inspect corporate records, the first thing they have to do is make a written demand upon the corporation that states the records they wish to review with specificity, along with their purpose for reviewing those records. If the corporation refuses after a written demand, the shareholder has a right to file a petition with the proper court to compel the corporation to produce those records. After the petition has been filed and properly served upon the corporation, a hearing will be held, at which point, depending on what type of record the shareholder wishes to review, a different party may have the burden of proof. If the shareholder wishes to review accounting records and the books of the corporation, the burden is on the shareholder to demonstrate that they have a proper purpose to do so. If the shareholder wants to review meeting minutes or the records of the identity of shareholders, then the burden is on the corporation, if they don't want to produce those, to demonstrate a lack of proper purpose. So the burden shifts depending on what type of record that you want to review if you're a shareholder. So each side will be able to make their argument and present evidence to the court as to why the record should or should not be produced. If the court sides with the shareholder that filed the petition, the corporation may be on the hook for damages, and these can be up to 10% of the value of the shareholder's shares, the petitioning shareholder's shares, in addition to any compensatory damages related to the corporation's wrongdoing. So that's how you get to see corporate books. And in addition to damages, the end game of that hearing will be that the court will issue an order compelling the corporation to produce the records requested. If they fail to do so, they'll be held in contempt by the court. So let's talk a little bit about LLCs. So far we've been talking about corporations. It's very similar, slightly different in the details. LLCs are required to maintain the following records: a list of members, including the capital contributions that each member has made, articles of organization, a copy of tax returns for the past 3 years, and any active operating agreement between the members. The operating agreement is just basically the partnership agreement between the members of the LLC. LLC members have a right to review all of these records that the LLC is required to maintain. In order to do so, they send a written demand stating with specificity the records that they wish to review to the LLC. The LLC will then have 10 days after receiving the demand to do one of three things: provide the requested information, or state a reasonable time and place where the requested information will be provided, or state that the LLC is refusing to provide the information and the reasons for such refusal. If the LLC fails to properly provide the requested information, the member of the LLC has the option to file a petition to compel the production of those records in just the same manner that the shareholder of a corporation has that option. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience that you can find on our website, o'flahertylaw.com. Actually, o'flaherty-law.com. And if you found this helpful, we'd love it if you subscribe to us on YouTube, Apple Podcasts, SoundCloud, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.